Testing 1 2. Testing 1 2. Why did that not work? Really? That's what we're doing today? Well, we're just not doing it. All right, welcome everybody. I'm Supreme Decisions, and tonight we're going to talk about prosecutorial misconduct, turning the state's mistakes into your defensive weapon. Now, tonight's probably going to be a little more than about 30 to 45 minutes, but I'm a little bit better prepared. Yes, this is my drink. There we go. Arizona RX, that's my drink, my favorite drink. I actually put it in my cup. But this goes into the weaponizing of your defense. And I've actually been doing this actively, more active lately than ever previously. But I've been doing this for almost 17 years. I've seen this differently than a lot of people have. And like I tell people, I don't play law. This is my actual life. This is my livelihood. This is, what it is right now. So now I'm going to be blunt. Prosecutorial misconduct is the most dangerous weapons that the government wields against defendants. Why? Because the prosecutor isn't just a lawyer. They represent the state, they command resources, and they're supposed to seek justice, not just convictions. But when they cross the line, when they cheat, when they withhold evidence, when they mislead jurors, they violate the Constitution and they violate their very duty of trust for the people and for the system in which they were chosen to uphold and defend. Today I'm going to break down how to spot misconduct, how to prove it, and most importantly, how to turn it into a weapon for your defense. I'm going to go into how to suppress evidence. I'm going to talk about mistrials, reversals, and sometimes outright dismissals. All right, this isn't theory. I told y'all I don't just talk. I give you things that's tangible that you can actually see and put your hands on. And we're going to use real Supreme Court cases, practical trial strategies, and my favorite, in some cases, an aggressive defensive tactic, because the best defense is a great offense. So in your midst of defending, be offensive. So again, attack, 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 attack. Now, once you find out what the exact ideals of misconduct look like and how to strike back when you see it, you're going to be empowered. And even if you have an inkling of fear, there's someone out here that not only can help you through it, but they can also make sure you see the justice that you're seeking. Now, because I'm not one of the piranhas, I'm what they call an out-of-town shooter, because I come in, handle business, and my priority is you, not the state, not the court, it's you. Now, I'm going to give you the legal foundations of prosecutorial misconduct. Definition: misconduct is any behavior by a prosecutor that violates due process or undermines a fair trial. This looks like a plethora of things. And in the context of that, most often is Brady v. Maryland, because that's the caveat and the foundation of every case. Most defense attorneys don't file a detailed discovery. Why? Because the prosecutors the one who's feeding them, because they work for the exact same people, and their checks have the same name on the top of them. So that means they're all part of the same corporation. All of them are a member of the same club. They don't want to go against each other. In order to make them do that, you have to pay them an exorbitant amount of money. Now, when you're going through this, they're not asking for a detailed discovery. They're asking for a vague discovery. So then the prosecutor doesn't turn it over, and they don't press the prosecution to turn over exculpatory materials because they're not on your team. And this is one of the things in which I also had a young man I was explaining to him how an attorney does not have a choice. When they're representing you, they are the employees, not the employer. They must follow your instructions. So even a defense attorney that's not following your instructions, your clear instructions, they're not maintaining your presumption of innocence. They are in violation of not only their bar card, their bar ethics, but also state code and federal law. So it's one of those where it can be encompassed in prosecutorial misconduct because the prosecutor has a responsibility to inform a judge if the defense attorney is not performing up to par. This is also grounds for prosecutorial misconduct. And this, like the Fifth Amendment's due process clause, it protects against unfair prosecutions. Sixth Amendment guarantees the right to effective, I'm going to say that again, guarantees the right to effective assistance. That's why you have, and I just spoke about it, ineffective assistance of counsel. That is a violation to your Sixth Amendment rights. You have the right to confrontation. If there's a call, or let's say they use the testimony of a confidential informant. Well, if they're going to use that confidential informant's information, they have to now have you confront that informant. But again, that's part of your effective assistance. And if you don't have it and it's not noted, that is prosecutorial misconduct. Now, the Fourth Amendment applies due process protections to the state. And also you have the right to an impartial jury because they also have to have instructions of your presumed innocence. And if they're not given that, your right to a fair trial, it has been affected. Now, your Supreme Court anchors is Berger v. United States. Prosecutor is not just an advocate, but a representative of justice. So whenever they're not doing that, they are in violation of law. Brady v. Maryland, suppressing evidence favorable to the defense violates due process. This also includes police officer Giglio information. Napura v. Illinois, allowing false testimony is unconstitutional. These are arrest warrants. These are chain of custody documents. These are police reports. That's why you're attacking and attacking and attacking. And when you're doing this in the aggressive framing, as your own defense counsel or your counsel of choice, they must assume that the prosecutor will push the limits. And if you're not watching every move, discovery, voir dire, closing arguments, you're leaving yourself vulnerable. Now, the common types of misconduct, again, Brady violation, suppression of exculpatory evidence, not disclosing lab results that weaken the state's case, just like when we talked about the police department in Illinois. The task force in Tennessee, where they're arresting people that have zero drugs in their blood and they're blowing zero into the breathalyzer. And the prosecutor saying people have an opportunity for mistrials. They have an opportunity for dismissals and not just dismissing the case when they know it is false. This is misconduct. The prosecutor is liable for those actions, including the district attorney. Improper closing arguments, vouching for witnesses. I believe this officer is telling the truth. That is leading and a violation. Appealing to juror bias. Don't let this criminal back on the street. Again, calling someone names that has yet to be proven as that name. Remedy. Object immediately. Preserve the record, which is going to get transcripts, and request curative instruction, which is basically corrective instructions, and move for a mistrial. Make sure that's locked and loaded, because even the sheer basics of all this, even if you're not a seasoned professional in this, you still have options that you have available to you, because again, you're here listening for a reason. Now, in Mooney v. Holohan and Napu v. Illinois, they condemned cross-examining hard, impeaching witness, and exposing inconsistencies. These inconsistencies that are consistent inconsistencies are in police reports, because they are not allowed to tell the truth, which is why they're using stock language, which is why it's pretty much the same language all across the country. And by not being able to tell the truth, even when they're writing the affidavit for the warrant, when they're writing the citation and then writing out the police reports, and when they're writing out the scene reports, there are going to be inconsistencies in most of them. So be on the lookout for those. Impeaching witnesses. Again, jiggly information. Now, abuse of discovery and grand jury process. Spoke about the grand jury yesterday or day before, because the indictment itself is just something else that you can rebut. Don't worry about it. It's just, for the most part, it's just a piece of paper. But what a lot of times what they're doing is overcharging to force pleas. This is a legal violation. And leaking to the press to poison the jury pool. This is one of those prosecutorial outreaches when they do a press conference and they name someone and say this person did this without fact. Because even if they retract it, the only thing the story is run on the front page. The redaction is buried in the middle of the news where nobody's watching. And it's always done that way. But you can weaponize that as well, because again, that is something that they can be prosecuted for. Now, proving misconduct in court. Documentation is king, because it's not what you know, it's what you can prove. Always create a paper trail, motions, objections, and transcripts. MOT, motions, objections, transcripts. Motions, objections, and transcripts. Make sure you're creating the right motions at the right time. You're objecting to everything in a timely manner, and you're offering up the correct objections, not just feelings. And transcripts. Get a record of every hearing that you go to. And when you see the inconsistency, we didn't have a court report on this day, then that day does not exist. Because now you got to explain why there was no court report and why there's no record of that court hearing. And always keep the letters that you get from them, because again, they will lie, they will attempt to cover up. And this is your paper trail. And always remember to answer. Not answering means acceptance. Now, your cross-examination. Force officers and other witnesses to admit to contradictions. Now, you've heard the story 1,000 times, where I spoke about the police officer and he was following me and all these other good things. He mentioned the warrant one time. I then got him to what do you call that? Yeah, I shouldn't be doing these late ones. He retracted his statement of having a warrant because there was no warrant, and I allowed him to use, oh, I misspoke. So, and I actually, okay, you misspoke about having a warrant. So you followed me illegally. And so, again, still kept it in there because now it's showing he's performing illegal acts outside the guidelines of his duties. These are things that can be used as a tactic for you. And box prosecutors into discovery violations by reading back their own filings. This is why whenever I do a detailed discovery, I tell everybody, I give you a list. It literally, check it off. It is literally a checklist. And it's specific to your matter. Always understand that. Specificity is the killer of bull. Now, here's the biggest part of documentation, objections, and transcripts. Because they will still steal from you. The appellate leverage. Prosecutor misconduct is one of the strongest grounds for reversal if properly preserved. Notice the word, because I've even said that properly written. I've used that about motions. I've used that about the trust. I'm now using that about setting up an appeal. The grounds is about staying purposeful and proper. And that's where most people fail at. Because you see something that some person did out here, they hand it to you, but they never told you how to use it. So they gave a child a handgun, and that's what happened. So understand, just because they give you something and it's something that's used does not mean you know how to use it properly. And if it's not executed properly, it becomes worthless. So it becomes a tool against you and not for you. Now, in most cases, you're going to file motions early. Something like your sanctions, your suppressions, your dismissals. But I shouldn't even use early. I should use the word timely. You're going to have timely filings of motions, suppression requests, and dismissal, along with sanctions, because there's a time and place for every one of these. Whether it's you want to come out, blasting them out, or you want to make sure you're laying that foundation through infamy and making sure that what you're doing is not something that allows somebody to come into the back door on you. So, your trial tactics. Object on the record every time misconduct occurs. Ask for a mistrial if the jury has been poisoned. And again, understanding the tactics that are available to you. Demonstrate misconduct can push prosecutors to offer reduced charges or favorable deals. It can also push the prosecutor, if executed properly, to a dismissal, because if you tie them up when you're filing your motions, when you're setting your complaints, you then add liability to them early. And you keep that liability on them as long as they keep up the fraud or the perpetration of charges where they know there are none. Now, this is something that also happens. People are convicted of crimes while having the prosecutorial misconduct ensue. And then you'll do a habeas corpus petition citing the due process violations. Generally, it's going to be at least 3 or 4. Generally. But understand you must have the proof of that. And also, don't expect the courts to move fast once you've been convicted. Now, your filings must be timely and all that good stuff. But don't expect fast movement if you are already, let's say, incarcerated. If you've been incarcerated and they took you to jail immediately, Yes, the habeas corpus needs to be filed, but don't expect fast movement because you're already in jail. And any movement requires them to apologize, which opens them up to liability. Now, understand on your appeals, most of the appeals are going to cite Brady, Berger, Napar, or Kyles. All of those are the majors. Not the only, but the majors. Those are the ones that you're going to be used most often. Now, just to give you a couple of hypothetical scenarios. Prosecutor hides a police disciplinary file. But again, it must be requested in your discovery, because if it's not requested, they don't have to turn it over. But if you actually request it and then they don't turn it over, you file a Brady motion, gets evidence suppressed, and you get your charges reduced or dropped, because it is a Brady violation whether they like it or not. If you request it, they must turn it over, because if you're requesting it, they are using that police officer's testimony to bring charges. So they must also bring that police officer's character to be impeached. And it's literally that simple. And the prosecutor in closing calls the defendant a dangerous predator. You object. Judge gives instructions, and a mistrial is often declared because, again, referring to someone outside of their name and making assumptions and testifying in closing arguments is a violation of a fair trial and law. This is misconduct. The prosecution is liable for that. Okay, the prosecution pressures a witness into lying. This is generally done by offering them something that they feel they need, which is a deal for whatever reason. You can do it, then impeach the witness. You can expose the deal, because again, this same thing with confidential informants, destroy their credibility, and you're generally going to be acquitted because no one likes someone that's trying to hire someone else to be shiesty. Now, ask a couple questions. You drop your answers in the comments, and let's start a little dialogue. Because if I suspect the prosecutor is hiding evidence, what should I do? Just take that for a minute and think about what you would do and write it in the comments. Now, one of the things that you could do is file a motion to compel. Demand in-camera review. That's one of the best because, again, you can now use their actions against them. You can't argue with yourself. Always understand that. That's more than, I say that more often than not. And then also, you're going to weaponize Brady v. Maryland because that's what happens. Can a conviction be overturned years after for misconduct? Just put your thoughts down there. Because even a habeas corpus petition citing Brady, Napar, or ineffective assistant counsel are valid even years later. The most common is ineffective assistance of counsel. Why? Because you have a right to effective counsel that defends you vigorously. Not my words. This is law and it's written. And what if your lawyer doesn't object to misconduct at trial? This is also a doozy, especially when you have a public pretender. You have grounds for ineffective assistance of counsel under Strickland v. Washington. Now, I actually thought it would be a little longer, but it's cool because I stumbled through it a little bit, but we got there. That's the whole point. Because now I'm going to wrap it up. Because prosecutorial misconduct isn't rare. It's real, it's dangerous, and it happens in courtrooms across the country. And it's happening every day. I wish I was exaggerating. Because if it wasn't, I wouldn't be here talking to you, and I wouldn't have these grounds and have done so many cases behind the prosecutor not performing law or even acting lawfully. And every time a prosecutor cheats, they hand the defense a weapon. I actually had a young man I spoke to earlier tonight. He said, "Oh, well, the prosecutor did this," and I just simply text back, "You have another bullet in the chamber." Because now you don't interrupt your enemies when they're doing themselves harm. Let's call it that. But on another platform, I'm gonna use different language, so understand that you'll understand what I'm saying. Because I think I've said it once or twice, but I'm gonna keep it PG right now. But understand, rather, your job is to defend yourself at all costs lawfully, because they don't follow law. They mean the prosecution, and make sure you're doing it when it happens. Call it out and weaponize it. This is the art of war. This is the one thing I talk about all the time. File motions, make objections, preserve the record, and when necessary, demand a mistrial, an appeal, or outright dismissal. Because even one of the things I actually learned to weaponize is the motion to take back a plea. Because a lot of people don't understand, a judge cannot enter a plea for you. And you must know the nature and cause of your action prior to setting a plea. And before you can make an informed decision, you must have discovery. So if they enter a plea for you, or even if you put in not guilty, just say you put in a not guilty, you still don't have discovery. So you don't know the nature and cause of this action. How can you enter a plea? You don't even know what they're charging you with. Don't even know what they're charging you for. And you're accepting what they're doing as lawful. Always understand that. Now, the Constitution is more than words on paper. It's a shield. And in the hands of someone that knows how to weaponize it, it becomes a sword. This is Supreme Decision. Remind you, don't just fight the case. Fight the misconduct. Until next time, keep your eyes sharp, your defense sharper. This is my 2 cents. Spend it how you like. And I'll see you guys probably in a couple hours. Let's keep going. Let's keep growing. Don't forget super chats and donations are welcome. And if you need a consultation, the link's in the description. If you need to email me, that's also there. And I'm out.